breaking news today.
Please subscribe and check notification box to get all breaking news alerts.
Breaking news. Holy hell. Trump made it happen. He's walking out on February 6th. In a move that has been way overdue. We are now getting reports that the British government is paving the way to allow Julian Assange to walk free from the Ecuadorian embassy on February 6. Without fear of arrest, as a British tribunal is now set to rule on lifting the UK arrest warrant. Interestingly enough, all this is occurring after President Donald Trump met this week with UK Prime Minister Theresa May. Assange's lawyer Mark Summers confirmed to the Westminster Magistrates Court that the withdrawal of the European arrest warrant would mean the British bail arrest warrant no longer applies. So he would have to be let free without any threat of arrest by UK authorities whatsoever. Reuters has also confirmed that Summers' argument to the Westminster Magistrates Court was a technicality. That the purpose of the UK arrest warrant was only allowed because of the legal proceedings which took place in Assange's Swedish rape case. In other words, the UK charges were only brought on to make sure Assange would face his charges in Sweden. Assange fled to the Ecuadorian embassy in the Knightsbridge district of London back in 2012 to avoid extradition to Sweden by skipping out on bail and seeking refuge in the embassy. But in an awesome turn of events in the CA, the Ecuadorians are now said to be planning to give Assange full diplomatic immunity, which would make him untouchable by UK law. All UK officials could do to him is declare him persona non grata, which would automatically give him a set amount of time to leave the country. Your Newswire reports. Trump's attorneys argue Assange's First Amendment right to publish. In a motion filed with the U.S. District Court for the District of Columbia on December 29, 2017, in the case Roy Cockrum v. Donald J. Trump for President, attorneys for President Trump argued that Julian Assange had a right under the First Amendment to publish the DNC and John Podesta emails, even if the emails were stolen. The case was orchestrated by Project Democracy, a group run by former attorneys from the Obama administration, arguing that then-former Trump campaign advisor Roger Stone had conspired with the Russians to publish the DNC and Podesta emails. In a 32-page motion defending the Trump campaign, Michael A. Carvin of the Jones Day law firm and the attorney of record representing President Trump, argued that the Trump campaign, and by inference Julian Assange at WikiLeaks, could not be held liable under the First Amendment for a disclosure of stolen information if the information published deals with a matter of public interest and the speaker was not involved in the theft. In making the argument, Trump's attorneys relied upon Burtnitsky v. Vopper. 532 U.S. 514, 2001. A labor union case in which the Supreme Court ruled a radio station had a right to broadcast a stolen tape of a phone call between the chief union negotiator for a Pennsylvania high school and the chief union negotiator together with the union president. Technically, Assange has not yet been indicted of any criminal offense in the United States, nor is it clear he has committed any crime. Under the Supreme Court decisions New York Times v. Sullivan, 376 U.S. 254, 1964, and in the Pentagon Papers case, New York Times v. U.S. 403 U.S. 713, 1971, a journalist is allowed to accept and publish classified documents provided by other sources. On December 29, 2017, Assange posted a tweet that referenced an article published by The Guardian on December 14, 2017.